think very, very important. And I'm sure all of you will maintain that uniqueness about this university, because we, the people of India, means the marginalized, downtrodden, weaker sections of the society, Indian society, who need to be actually taken to the heights where they achieve social, economic, political justice. Now, the topic that I have been asked to talk about is something which is very familiar to me. Shakti approached me, said, "Sir, I just want you to interact with our students on this topic." I was very happy because it gives me an opportunity to come back to the Faculty of Law, University of Delhi. I started my career from here. I of course ended my career here. In between I went for 4 years to Delhi Judicial Academy, but then my heart was there only. So it's very homecoming for me to be with you today and tell you how important it is for you to take the best benefit of the case material that we have prepared for you. I have always said one of the most distinguishing features about Delhi University Law School is that it has a unique contribution to make to the legal education is its classic case material. And I will demonstrate to you today. I am not going to talk anything outside the case material. I'll show the beauty of the case material, how to read a case material, and how to understand the subject. This is not a subject, separate subject. It's a subject which you have studied in all subjects. Why we teach interpretation of statutes in the final term? I think there's a logic behind it. The logic is this: if we teach you this subject or take this subject to you sometime in first year, second year, then you will make life miserable for your teachers. You say, why not this rule, why this rule, why this interpretation, why not this interpretation? That is why we want you to first read all the cases. And then when you come in the final term and you are about to leave, we tell you what the rules of interpretation are. So that you make use of these rules when you go to the court of law. Tell the judges why you want them to interpret this statute in this particular manner. And what is the foundation for your argument? Now, it's a very important subject. I would say, if today I find, my students are doing very well, they're doing better than me in the profession, and I ask them what is the reason, they say because we studied the subject with all seriousness it deserves. And that is why I say all of you need to study this subject with all the seriousness that it deserves. Now let me take you to this subject. We say interpretation of statutes. So therefore it presupposes a statute. What is a statute? We say legislation passed by a competent legislature. And there is always a presumption when a legislation is made that it is constitutionally valid legislation. Please be very clear on that. When a legislature passes a legislation, presumption is that it is valid. A legislation can be declared invalid only on two counts. One, either it is beyond the competence of the legislation. Therefore, a person challenges the law in the High Court or Supreme Court because they have the extraordinary jurisdiction, and they are the constitutional courts. They are the courts which can go into the constitutionality of the legislation. If an issue of constitutionality arises before a subordinate court, I of course don't like the word subordinate court, I would like to say district court or courts which are part of the district judiciary, they cannot decide that question because they have to send a reference then to the High Court. And I will show you the cases. Those of you who are students of interpretation of statutes, you must have seen one of the cases which has been sent by the lower court to the higher court as a reference was the case Revert Stanley's case on the question of the constitutionality of the conversion law. Now that is something which you should, every case has to be studied from various angles. And that is why it is the beauty of this subject. A legislation can be challenged on two counts. One, constitutionality, that is competence of the legislature. Second, it is violating of the fundamental rights. Or it is violating of some basic structure of the Constitution. Or it is violating of some express provisions of the Constitution like trade, commerce, intercourse. So therefore these are two very important aspects. Therefore, what is a statute? A statute, we call it as the will of the legislation. And you know, will comes into effect only after the death of a person. Similarly, when a legislation is passed, a bill is passed, it is voted. When it is voted, it is the collective wisdom of the legislature. And it is the collective will of the legislature. During the course of the debate in the assembly or parliament or in the constituent assembly, every member can express his view. But when you go to the debates in the parliament or debates in the constituent assembly, you will find that individual members' view is not the collective view of the legislature. Now this is a very important distinction that you have to make. That is why when we talk about the external aids, and I'll come to those different parts of the statute, but first I would like you to come to Ramachandra Rao's 7 judges bench of the Supreme Court was dealing with the question, and I would like you to, those of you, how many of you are students of interpretation of statutes? Almost 50%. Kindly go to the very first para of Ramachandra Rao. I will like you to kindly appreciate the question. And that question is important from the perspective that I would like you to understand. It's a 7 judges bench. Because Anthony's case, which is reconsidered in this case, was 5 judges. So when a matter needs reconsideration, you always constitute a larger bench. So the question in this case, you will find that the question that the court asks itself is, in its zeal to protect the right to speedy trial of an accused, can the court devise? Now mark the words, because it brings in the question of the separation of powers, and I am coming to that part of the discussion because that is the base. Legislature will make the law, executive will implement it, and judges will only interpret the law. But to what extent can the legislature go? Where is the Lakshman Rekha to be drawn? Every day you find judges and parliament talking about the Lakshman Rekha of each other. Where can this Lakshman Rekha be drawn is a very important question. Now, kindly see, that is where I am going to give you a broad idea. I do not know how much time we have available, but I would like to cut it short to the extent I can. But I would like also to introduce you to the various rules and of interpretation. But just kindly see, in its zeal to protect the right to speedy trial of the accused, because Supreme Court has read after Maneka Gandhi, right to speedy trial and right to fair trial as fundamental right derived from Article 21 of the Constitution. But if you read Muhammad Hussein's case, the Supreme Court says there is a distinction between fair trial and speedy trial. Speedy trial is a relative concept. Fair trial is an objective concept. Please be clear on that. There was a case which went to the Supreme Court, and you must all read that case. Ranjan Dwivedi. All of you must be aware about Ellen Mishra murder. This matter went for more than 25 years. Ranjan Dwivedi was one of the accused in this case. He went to the Supreme Court, said 25 years have passed by. The end of the trial is nowhere visible. I have a right to speedy trial, they will quash the whole trial. Please understand. The Supreme Court said, let us call for the records of the case. The Supreme Court called the records of the case and found the presiding officer had in these 25 years adjourned the matter only on 5 occasions. On all other occasions, it was one of the accused was putting spikes and was not allowing the trial to go. The court said, you have not come to this court with clean hands. And it patted the trial judges for the exemplary work they did, that only on 5 occasions they allowed the trial to be adjourned. On none other occasions, because of the magistrate or before the trial court, it was adjourned. Therefore, the Supreme Court said, you are not entitled to the speedy trial. That principle does not apply to you. Please understand that aspect of it. So, kindly see, in its zeal to protect the right to speedy trial of an accused, can the court, now this is the question that the Supreme Court is asking itself, can the court devise and almost enact such bars of limitation, though the legislature and the statute have not chosen to do so? Is the question of far-reaching implication which has led to the constitution of the bench of 7 judges of this. Can the court, in absence of a statutory legislation, statutory provision, legislate and lay down the bars, because there were 2 cases common, this common cause, and the case of Rajdev Sharma 1 and Rajdev Sharma 2, where the courts had laid down the outer limit 2 years, 3 years, then the trial should be quashed. Supreme Court said, we cannot do it. You cannot lay down a general rule. And the field is already occupied. I am sure those of you have read CRPC. There is a provision, section 309. We say, once the trial commences, the court shall hold the trial on day-to-day basis. And that is where we say occupied areas and unoccupied areas. When we say statute, we say occupied area. When we say Vishaka, there was no law dealing with the harassment of the women at the workplace. So the Supreme Court, in absence of a law on the subject through statute, found a vacuum. Therefore, on the basis of the CEDA, read international law into the domestic law, but laid down the directions only till the Parliament intervenes. So therefore, the fundamental question that I am going to talk to you now is what is in Ramachandra Rao itself. Justice Lahoti's judgment, if you read, it takes me, I am telling you honestly, it takes me at least 5 to 6 hours to read a case. But I think if people can read it even in 1 hour, half an hour, 15 minutes. But when I started reading for this lecture yesterday, I could read 4 or 5 cases. Rest of what I talk to you is something which is, just that 15 minutes, 10 minutes, 20 minutes, I just glance through those cases. But this case, I spent a lot of time on this, therefore I want to take you to your case material and tell you how to read the case material. If you come to para 26 of this judgment, if you have the para 26 of the judgment, please come and let us read this. In fact, not 26, I think we'll like to go straight away to para 26. I'm sure it is para 26, yes. Please read with me. I'm in the middle where they are quoting Professor Sathe. Now this is the importance of an academic. The Supreme Court quoting with approval something what an outstanding scholar. He was in my selection committee. I was not appointed professor in that selection. For whatever reason it was, but I had no grievance because I said he is a scholar of great repute and it was all people of great repute. But then there are things that happen at the back also, but that's all right. I had no grievances, but I acclaim him as one of the outstanding scholars of this country. And read his book. If you want to understand what Constitution is, what contribution of the Supreme Court is, where the Supreme Court has gone wrong, there is a book written by him, Judicial Activism in India, Transgressing Borders and Enforcing Limits. Just let me read one para. The doctrine of separation of powers, and that is the foundation of the subject. The doctrine of separation of powers envisages that the legislature should make law, the executive should execute it, and the judiciary should settle disputes in accordance with the existing law. In reality, such watertight separation exists nowhere and is impracticable. It means that one of the organs of the state should not perform the function that essentially belongs to another organ, while lawmaking through interpretation and expansion of the meaning of open text expressions, such as due process of law, equal protection of law. Our Constitution makes us went all the way to United States for a discussion with Justice Frankfurter and wanted his guidance as to how they should make the Indian Constitution. He said, don't make the Constitution like United States Constitution, make it very broad. Cover almost everything in black and white. Don't leave much for judicial. But then the language being what it is. When you use personal liberty, when you use procedure established by law, when you use freedom of speech, these are open textual words. Depends upon the kind of judges we are talking about. The same Constitution was before Vedanjan Shastri when he decided Gopalan's case. Same Constitution was before Bhagwati Jay and his team when Maneka Gandhi's case came. Because much change had taken place on the political scene and societal scene in India, and judges did not want to lose their legitimacy. They wanted to regain their legitimacy, and therefore they wanted to open the doors of the Supreme Court ajar and allow the people to approach and have access to the court and read in the contextual, context, social context certification they started, and you have Maneka Gandhi, which opened, I think, one of the most important eras in the Indian constitutional lawmaking. Now he says, such due process of law, equal protection of law, freedom of speech, expression is a legitimate judicial function that makes an entire new law through direction is not a legitimate judicial function. I'll just come back to what I was trying to talk to you. I'll just take you to para 25, a very beautiful para. And that is the whole of the common law. Those of you who read criminal law, Mayor Henry George, कितना आसान है, Foreign Exchange Regulation Act, Section 8 of the Foreign Exchange Regulation Act, criminal law में पढ़ा है. Each one of them has read it. What does Justice Subarao say? What does the majority Justice Iyengar say? They say, although we have the codified IPC, but actus non facit rea missi mensit rea, a common law principle accepted by Indian courts. Foreign Exchange Regulation Act, which says whoever brings or sends gold in India